The broadcast is now starting. All attendees are in listen-only mode.
Hi, good afternoon, everyone. We're going to get started on today's webinar, Understanding Suspension and Debarment. Thanks for joining us. My name is John Williams, and I'm joined today by Alex Levine. Both Alex and I work in the Government Contracts Group here at PilieroMazza. For those of you who don't know us, we're a boutique law firm in Washington, D.C. We do government contracting with a focus on the federal procurement programs for small businesses. We also work with labor and employment law issues. We do corporate law and civil litigation. And one of the things that we've been seeing with increased frequency recently are suspension and debarment oriented actions, whether it's an IG investigation or a proposed debarment, a suspension. It's happening with increased frequency, including for small business contractors. So we wanted to share some of our experiences today, provide some tips on how to navigate and understand the process, and hopefully never find yourself in that situation to begin with. So the next slide here shows us where we're going to go today. We're going to start by talking a little bit about the current climate, give you a flavor for what's out there and what is informing why we're seeing an increase in suspension and debarment activity. And then we're going to work through several questions that we want to answer for you. Why does the government suspend or debar a contractor? What does it mean to be suspended or debarred? What process does the government follow to suspend or debar a contractor? And then we'll wrap up with some tips for avoiding and navigating the suspension and debarment process. And we're going to try to land at about 2:45 when we're done with our presentation, so we save enough time to answer your questions at the end. So, but you don't have to wait until the end to type in your questions. Go ahead and fire away. I see we already have a few questions coming in. We'll answer some as we go along, but we'll try to reserve time at the end to answer questions. And anybody whose question we do not get to today, we will follow up with you afterwards via email. And just so that everybody knows, you will get a copy of the slides via email once the presentation's over with. And then within about a day or so, we will have the slides and the audio posted on our website at www.PilieroMazza.com/presentations. So a couple of ways to make sure everybody who wants them can get access to the slides. All right, so let's talk about the current climate. What's out there and what's really driving what we're seeing from a suspension and debarment standpoint. Transparency, that was a big buzz phrase when the Obama administration started. One of their main focal points was to stop waste, fraud, and abuse in government contracting. So there have been a variety of initiatives along those lines over the last several years, and that's having now an impact on the number of suspension and debarment matters that we're seeing. There are mandatory self-reporting requirements. These have been around for several years. We'll get into them in a little bit more detail later, where contractors are required essentially to tell on themselves in certain circumstances, and the penalty for not doing so includes possible suspension and debarment. We're seeing a lot more audits and investigations. SBA IG, the Department of Labor does a lot of investigations for Service Contract Act compliance and things along those lines. We've even seen a few performance of work investigations. For a small business set-aside contract, is the small business prime contractor performing the required amount of the work? And it's a highly competitive environment, and you don't need us to tell you that. You already know. But what that's led to is a lot of protests. And interestingly, protests have begun to spawn more suspension and debarment-oriented activity. Whether as a direct result of the protest or because of things learned in the protest, and that could be the agency decides this should be investigated further, the trier of fact decides that, or maybe it's just the competitor that learns information or thinks I need to press this issue further. But protests are having an impact in this arena. the SBA has a new presumed loss rule, and I want to make sure everybody, particularly if you have any involvement in set-aside contracts, whether you're a small business or you're a large business that works with small businesses, I want to make sure that everybody understands the presumed loss rule. So I'll spend a few minutes talking about that rule here in a moment. And all of this is leading to the bottom line, which is the last bullet here, that suspension and debarment activity is up significantly in recent years. We're seeing a whole lot more of it, and an important characteristic of that is we're seeing more fact-based investigations by and suspension debarment activity by the agencies, as opposed to they're waiting for a contractor to be convicted of some civil or criminal matter, and then it turns into a suspension or debarment as a second step. We're seeing more proactive investigations by agencies to determine, before there's been a civil or criminal finding, whether or not suspension or debarment is warranted. So particularly at certain agencies like DOD agencies, you find a more aggressive climate right now in pursuing these types of matters. So I mentioned the SBA's presumed loss rule. This went into effect last August, and we did a webinar about it, so you can go to that same website, www.PilieroMazza.com/presentations, and check out the slides and the audio to learn more about the rule. But just to give you a quick overview, this rule implements the 2010 Small Business Jobs Act, which created a presumption of loss provision that was designed to prevent and deter fraud and misrepresentation in small business procurements, and also, or primarily maybe, increase prosecutions of those types of cases, which maybe aren't necessarily the sexier cases that get a lot of attention at DOJ, but when you can attach a larger dollar amount to it, you get more visibility, more attention. And so this presumption of loss says that the government is presumed to have a loss of the entire amount of the contract if the contract is obtained based on a misrepresentation of size or status. So, we've seen some cases where that's a big loss then, $100 million contract that a company never should have won because it misrepresented its small business status. So the loss to the government is $100 million. So those cases we are seeing more prosecutions of cases like that. Just to drill down a little bit on the elements of the presumed loss rule, I mentioned that there's multiple elements, the primary one being the presumption of loss. So this establishes that the government does face a loss in this amount if you willfully misrepresent your size or status. The presumed loss rule also has provisions about deemed certifications. When a contractor is deemed to have certified its small business size or status, and to have done so willfully. So when you submit a proposal, or when you fill out information on an online database like sam.gov, you are considered to have made a willful representation of your size or status. So you've got to make really certain in this climate that those representations are accurate. The presumed loss rule also carries with it a signature requirement, that they now want a authorized official of the company to sign on the very same page that the company makes its representations for the contract, so that it's clear that this particular authorized official was signing off, and that they don't want it to be an electronic signature. So it was an actual sign-off on whatever representations of size or status they made for the contract. And that's I don't think that requirement has caught up with the FAR yet, or the FAR hasn't caught up with that requirement yet, because I think the reps and certs don't currently provide for a wet, quote-unquote, wet signature on the representations and certifications. But we've advised people they ought to start including a signature of an authorized official, like on a cover page or a cover letter to the proposal right along with their representations, just to be sure that you're in compliance. There are provisions that talk about limiting liability under the presumed loss rule, and we got into more detail on those in the earlier webinar, so I won't spend too much time on it here. But there are ways that, particularly if it was an unintentional error, that you can look to limit liability under the rule. And there's an annual recertification requirement in SAM, so you're having to update your status every year. In SAM, I'll talk a little bit later about the applicability to subcontractors. I think that's an important point. We're going to come back to it. And I think key for purposes of this presentation, the penalties for being out of compliance with this rule includes suspension and debarment. So I think you'll see that the presumed loss rule is a primary way that a suspension or debarment official can go after a small business for a misrepresentation of size or status on a set-aside contract. Just a little bit more here on the presumed loss rule. I think we'll just run past this quickly so we can get into the suspension and debarment information. But it's a rebuttable presumption. So that's helpful. It allows you to show mitigating circumstances, and some cases are going to be grayer than others as to whether maybe you had an affiliation or your revenues were over the size standard. Some cases are going to be black and white. Some cases are going to be grayer, and that the rule does allow some flexibility there. But a prime contractor may be liable for a misrepresentation by its subcontractor. So that's an important issue. The presumed loss rule applies at the subcontract level. So when you're submitting for a subcontract on a federal project, you're making a willful representation of your size or status, and then your prime has to have a good faith basis to rely on your representation. And otherwise, the prime could be liable. So we'll talk a little bit later about what we think primes should be doing to protect themselves there. Okay, so with that background, let's talk about what triggers a suspension or debarment inquiry. How could this come up? And it could happen in a variety of ways. It could be as a result of an IG investigation, a contract audit. There could be a criminal investigation that touches off a suspension or debarment proceeding. It could be because of a contracting official, maybe somebody that has a bone to pick with you, or has a legitimate reason to send a matter over to the agency's suspension and debarment official. It could be a complaint from a competitor or a whistleblower. We're seeing a lot more of that. Competitors want to send letters to the IG or to the SDO, which is the suspension and debarment official, complaining about their competitor, and those can lead to investigations and suspension and debarment actions. Public disclosures, and even, like I mentioned at the outset, adverse protest rulings. That's becoming more of an issue, particularly in the realm of the presumed loss rule that we're now living with. Okay, so our first question we want to help answer for you today, to give you some background on the suspension and debarment process. Why does the government suspend or debar a contractor? What we have on this page is sort of the basics right from the FAR, that the agency shall impose debarment or suspension to protect the government's interests, and only for the causes and in accordance with the procedures set forth in this subpart. It's supposed to be based on serious misconduct that the government determines that it needs to be protected from the contractor because the contractor is not, quote unquote, presently responsible. And I think the word presently there should be emphasized, that it's not, and I'll talk about this in a moment, it is supposed to be about protection from a contractor that in that moment is not responsible to do business with the government. And you should also be aware that the government can suspend or debar a contractor based on actions by the employees of the contractor, even lower level employees who are actively engaging with the government. So beyond what the FAR says, here are some practical considerations about why an agency suspends or debars a contractor. It's not supposed to be a punishment, but suspension and debarment is a punishment. I mean, it's really difficult from Alex and my perspective to view it any other way. I mean, a contractor is being punished, and because these things normally come about as a result of an investigation that takes some time, they normally do also pertain to things that already happened and not necessarily quote-unquote present responsibility. So you'll hear the government say a lot that it's not a punishment, it's to protect the government's interest against a contractor, but it really, in our view, it really is a punishment. It shouldn't be used that way. It's not supposed to be, but that's sort of the reality of how it works. Whether something is serious enough to rise to the level of the suspension or debarment is in the eye of the beholder, and reasonable minds can disagree. I think the reality, though, is that once it gets on the right person's radar at the government, it is serious. Because if they're sending you a notice or opening a file, it's a serious matter at that point because they've determined it to be. And we've seen some cases where political and other forces can work against you at sort of at the early stages when they're determining what they should do with the matter. The people who work in these offices, the suspension debarment officials, and that's their job. They have to be tough on crime, I like to say. They have statistics. So they have a job to do, and that job can be subject to political and other forces that are outside of the realm of the circumstances that you're dealing with your matter. So a relatively small or even possibly insignificant issue can be elevated because of that. Sort of once the train leaves the station, it's sometimes hard to put it back. And to keep going with my train metaphor, which my 3-year-old would love, there's a high potential to be railroaded in this process, particularly for smaller businesses. That's our experience here. We're a firm that works primarily with small and mid-sized government contractors, and those are the ones I think you tend to see have a more difficult time with the process, with agencies less willing to meet with them. You see the bigger companies on the front page of the Washington Post, and you almost can't believe how quickly they were able to get in for a meeting, how quickly they were able to resolve the matter in some form or fashion. And it generally doesn't work that smoothly and that quickly for small businesses.
This is Alex, and just one kind of anecdote to piggyback on top of John's. You had 5 or 6 years ago, IBM got suspended, and in 8 days they were able to get that suspension undone, and that's something you just would not see in the same kind of situation with a small business.
Yeah, it's a great point. So it's, I don't know that there's a whole lot you can do about that if you're sitting there listening as a small business, and we'll talk about ways that we suggest you handle the process, but it's sort of the reality of the circumstances that whether it's admitted or not, I think there really is such a thing as too big to debar. They're too important to the government, whereas smaller businesses, I think, can be viewed as lower hanging fruit. And when you go back to we have our statistics and we have to be tough on crime viewpoint of the suspension debarment officials, that sometimes makes it more difficult for the small business to navigate the process than it should be. So to go back to why does the government suspend or debar? Well, there are causes of suspension and debarment, and these come right from the FAR. And the FAR says they're supposed to suspend or debar you only for the causes in the FAR. So, it's important to look down this list and get a sense for the types of things that could get you suspended or debarred. And I don't think a lot of this stuff is going to come as a big shock. The one I would point out on this slide is the lack of business integrity, which is a very, I think, slippery concept. It can be twisted to suit an agency's purposes, I think. So it's sort of a loose standard there. Flipping to the next slide, there are more causes. This first main bullet with the two sub-bullets, this really captures the mandatory disclosure requirements that I mentioned on the climate slide. That you have to tell on yourself when you have a credible evidence that there's been a violation in connection with your contract of things like federal criminal law involving fraud or conflict of interest, etc. And this mandatory disclosure requirement applies up to 3 years after final payment on any government contract. So, there's a look back there. It's important that you're aware of that, and as we get into some of the things you can do, that you have policies and procedures in place to support the kind of reporting and disclosures and investigations that you need to do to stay ahead of things like this. The last two items here, improperly obtaining competitors' information and also source selection sensitive information. There might be circumstances where you did not improperly obtain this type of information. It's probably relatively narrow circumstances, but that's why we say improperly obtaining this information. And this is the kind of issue that could first arise in a protest. That somebody raises a question about unequal access to information or some kind of an OCI issue, and then it might mushroom into a broader issue beyond that. And the last slide here on causes is specifically related to small business issues, because I know we have a lot of firms participating today that either are small themselves or work with small businesses. So we talked about the presumed loss rule, and that's where we get this cause of suspension or debarment related to size and status misrepresentations. So when you're submitting a proposal or registering in SAM or any place else where you're representing your size or status, you are subject to suspension or debarment if those are inaccurate representations. And we talked about that it applies to subcontracts as well, and the prime contractor may be liable. You're also subject to suspension and debarment if you make false statements in SBA applications and other proceedings. This kind of goes, particularly for proceedings, it goes hand in glove with the size and status misrepresentations, but we had a case several years ago where a company was suspended and proposed for debarment based on statements that the principals had made in an affidavit submitted as part of a size protest response. And this affidavit helped the company to get a size determination that they were small, so they were able to perform the contract. But it later came to light as a result of an IG investigation that some of the statements in that affidavit were false, and the SBA took the position that they would not have found the company to be small if they had known the way the affidavit arguably should have been written. And as a result, there was a prosecution of the principals involved. So again, you just have to be very careful with the statements that you're making in your SBA applications and proceedings. The failure to comply with the limitations on subcontracting, this is an interesting one. If you're doing set-aside contracts, you're going to be subject to performance of work requirements. So you're going to have to, as a prime, perform a certain percentage of the work, depending on the type of contract. To this point, there really have not been very clear penalties for non-compliance, and it's been, I think, a relatively unenforced requirement compared to some other set-aside oriented requirements that are more regularly enforced. It's an issue of contract administration, so I think there's some question of who's supposed to be looking at this once the contract's awarded. But to address some of those issues, the 2013 NDAA included new provisions on the limitations on subcontracting, including penalty provisions. And the penalty provisions include, in addition to fines, suspension and debarment liability. So it can be a cause for suspension or debarment. That's an important new development. I don't think, again, that the FAR has quite caught up with that yet, but that has been law since January of 2013. Suspension or debarment can extend to affiliates, and I think Alex will talk a little bit about that, and I'm going to turn it over to him here in a minute. But that's an important, affiliates has an important connotation from a small business standpoint. It can extend to your affiliates, companies who you are actually affiliated with, you acknowledge affiliation with, and it could extend to companies that you're found to be affiliated with. So it's important to keep that in mind. So the FAR does provide mitigating factors. So when the government is considering why would they suspend or debar a contractor, they're supposed to look at various mitigating factors, and the important threshold point here is that just because there's cause to suspend or debar does not require them to suspend or debar. The government is supposed to weigh the seriousness of the misconduct against whatever the contractor has done to remediate the situation voluntarily and whatever else the contractor is prepared to do by agreement with the agency. So you should not go straight to suspension or debarment just because there's cause. There should be an investigation. There should be some consideration of factors, including some of the things that we've listed here. How much has the contractor cooperated? Have they done their own full and open investigation? Do they have effective internal control systems at the time that the incident occurred, or did they implement some before the government started to investigate? A lot of this is, and we'll talk about this when we get to the tips section, it's what have you done on your own voluntarily ahead of time? What did you have in place when it happened? And then that allows the government to look at then what else do you need to do and how sufficient was the controls and other things that you had in place when the incident occurred. And maybe more importantly than any other factor, recognition of the seriousness of the misconduct and a commitment to avoiding recurrence. That there is an element here, I think, was particularly when you're going in to meet with suspension debarment officials, of falling on your sword. That we recognize that we screwed up, even if maybe we don't entirely agree with the government's position, that there's something here we could have done better, maybe a lot we could have done better. We've already taken actions to correct certain things, and we're willing to go even further to make sure this doesn't happen again. I think that maybe more than anything else is what the government official is looking to not just hear from the lawyers, because we know how to write the response, we know the buzzwords and the FAR, et cetera, but oftentimes they want to hear it right from the business owner. And that's important as we move along into some of the things you can do in navigating the process. I think having that come right from the principals is key.
I'll take it over from here, this halfway point. We want to kind of touch on what exactly it means to be suspended or debarred, and what it means can probably pretty easily be stated in what you cannot do. And what you cannot do is you can't propose on contracts, you can't win new contracts, you can't have your options exercised or receive any kind of extension on your current contracts, and you can't receive orders under the schedules, BPAs, or IDIQ contracts, with the exception of orders to meet the minimum. That can be, that's not set in stone. If the agency finds compelling reasons that they have to go with you, they can make a determination by the head of contracting authority, but that's obviously a very rare occurrence that they would kind of make that determination. What you can do is you can continue with your current contract performance in your current contract, with one caveat, that the government can use the suspension or debarment as an excuse to terminate you. So kind of looking at the differences between suspension and debarment, this is really the crux of the matter. Between suspension is more of I mean, they're both preventative measures to protect the government, but the suspension is kind of buys the government time by kind of putting as a prophylactic measure almost to put a suspension in place while it's investigating, while it's making a determination on debarment. So that's kind of what it's envisioned as, and it's usually 12 months, but it can be extended up to 6 months more if an assistant attorney general requests an extension. And it actually can be extended even more. There's a recent case, Agility, where a government had brought an indictment against a contractor and had begun litigating against them, and the court said that you could have the suspension in place longer than that 18 months. And then a debarment is usually limited up to 3 years, but it can be also extended if the government finds it's in its interest to do so. It's effective across the government, so if you get debarred or suspended at the DOD, for instance, it will affect you everywhere at the government because it'll just be listed at sam.gov, which is formerly the excluded party list server. So, and of course, as I mentioned, if a particular agency finds that there's compelling reasons to justify business dealings, they can continue to do business dealings, but that's obviously very rare. It applies to all divisions or organizational elements within the contractor, and it can also apply to state-level contracts too, because what you see is a lot of states and local governments monitor the federal list. Some states actually, like Massachusetts and Maryland, for instance, they automatically put you on the state-level suspension and debarment list if you're on the federal list. Other states, if they kind of find that notification, they'll do their own investigation and kind of make a decision about whether or not any kind of state procurements can go your way. It also can impact your commercial contracts because a lot of people who are conducting commercial dealings will ask about it or will investigate it. Sometimes these things can be on the front page of the news, so it can be kind of well within the public realm that this is happening. It can also impact subcontracts. There's a clause that's required to be in every contract that over 30,000 that says that you cannot have a new subcontract with a debarred contractor unless there's compelling reason to do so. And any kind of, if you find that there's compelling reason to do so, you have to notify the government and you have to get the government approval. This doesn't apply to commercial off-the-shelf items, but other than that and the $30,000 limitation, it's broadly applicable. The other kind of impact here is on notification requirements. Once you're suspended or debarred, you have some obligations probably to notify certain people. The one that stands out is security clearances, where if you've gotten security clearances based upon representations for cleared personnel or key management figures not being suspended or debarred, you're under an ongoing obligation to notify DSS and let them know of the change. And there's also kind of a catch-all notification requirement for any adverse information. Suspension and debarment it not only affects the contractor, it can also affect individuals as well, mostly principals of the suspended or debarred contractor, which can include officers, directors, owners, partners, and any kind of key personnel. And those individuals cannot work for a contractor as an agent, a representative, or a principal. So if you're caught up in the web and you're kind of named specifically, what that means is that you won't be able to kind of escape it by going to a separate contractor. You're going to and that'll affect you if you try to get employment with another contractor. They'll ask about that kind of thing.
Yeah, and I just wanted to jump in to mention a case that Alex and I were working on recently where a contractor had hired someone, and it was a question of whether or not they were a principal, whether they were a key employee. And that is not necessarily an easy thing to answer. So if you have a situation where you're looking to hire somebody that has something like this on their record, or even if not a formal suspension or debarment, something along those same lines, you have to crunch whether this person falls into any of these categories. And it's a little bit of of a fuzzy definition, I thought, for what is a key employee.
The other thing here is that they can go after affiliates. They can and do that all the time. And the interesting thing about going after affiliates is that the affiliate doesn't have to be a participant in the wrongdoing. The case law kind of says that as long as the affiliate is specifically named and given written notice and opportunity to oppose the suspension or debarment, they can be suspended or debarred even if they didn't participate in the wrongdoing. And the reason is that affiliate, it's based on a control theory. So it's the bad actors are, in theory, the ones controlling the affiliates. So even if the affiliate is innocent of wrongdoing, the government feels like they need to, in order to protect themselves, go after all of the affiliates. Another kind of point here is there's a recent case called Agility that just came out where the affiliates protested the fact that the government, the DOD, I think it's DLA, cut deals with some of the affiliates, some of the organizations within the affiliation, and gave them, kind of cut their suspension and debarment terms. And two of the affiliates tried to get that same deal, and the government didn't give them the same deal. They said, no, we're not going to accept that deal. We're going to still put the suspension in place for you. So as that kind of sounds like, there isn't necessarily any kind of guarantees of fairness here when we're talking about protecting the government. The government feels like they have to do whatever is necessary to protect themselves, and doesn't mean that they'll necessarily be fair with all parties involved. So this next question is, what process do they follow to generally suspend or debar? And debarment, they have kind of more procedural safeguards in place, more fairness, where they will notify you before they debar, and ultimately it's going to be based upon a preponderance of the evidence, including the information you're going to get to submit to the suspension and debarment official. In contrast, the suspension is oftentimes, it takes place before the contractor even has an opportunity to submit information. Sometimes the first time a contractor even finds out that it's being investigated for suspension or debarment is when it gets that notice that it's been suspended. And that's what you saw with the IBM case, where IBM, obviously a major corporation, was not told before it was suspended. It just got that notice. And the reason was the government felt there was an award coming down and a multi-million-dollar procurement. IBM, they felt, had taken improperly its competitors' information. They felt like in order to protect themselves, they needed to impose that suspension right away, and they did. Suspension has a lower standard. It's adequate evidence, which is kind of akin to a probable cause. So you don't need that full preponderance of the evidence. You just need adequate evidence to find that the government needs protection for the short term. The general process you see is that the first you hear about it usually is with a written notice. That could be a notice of suspension, notice of proposed debarment, or even a show cause notice why we shouldn't suspend or debar. The notice will list kind of what's being considered, what are the reasons for it, and if it's a notice for suspension, it will explain why the suspension has been imposed. Usually you have 30 days to respond, but that's not written in stone. You can kind of contact the agency and ask for more time. The initial burden is usually in these types of proceedings is on the government, and then once the government makes out that initial case, the burden shifts to the contractor. What you see you have more kind of procedures in place where there isn't that kind of conviction, indictment, or civil judgment. Generally, if there isn't that, the contractor has the right to appear with its counsel, submit evidence, present witnesses, or confront any person the agency is presenting. There's also in rare cases, there's fact-finding procedures where the agency will kind of make determinations of fact. Those are not common, but they're definitely increasing more recently. Different agencies have different procedures. The FAR kind of sets out a common set of standards, but it doesn't really go into the process too specifically. And there are important differences between the agencies and how they run it. I mean, the big one is that agencies have different levels of staff and resources. So you see some agencies like the DoD agencies and the GSA, EPA, with a lot of experience. They kind of have a set amount of staff that does their investigation. They have a kind of, this is what we do. They have their procedures all down. Whereas the inexperienced agencies are more likely to kind of be winging it and trying to figure out kind of what the next step is. You see a lot of inexperienced agencies dwell on cases and events that occurred a long time ago because they're not as focused on present responsibility as they should be. Whereas kind of with the DoD, you're more focused on present responsibility and kind of actions impacting that now. The process is very slanted towards the government in terms of suspension and debarment, and the main reason for this is because the goal is to protect the government, with fairness as kind of a secondary consideration. And that's not to say fairness is not in play. There is obligations to fairness, and there is review here. And what you can do is you can review any kind of decision with a federal district court under the Administrative Procedures Act. The problem is that this has generally been a very deferential standard to the agency. It's been very rare for them to overturn an agency decision. There was a very recent case called Inchcape Shipping Services where they actually, it was a Court of Federal Claims, but they reviewed and overturned the agency's, I think it was a debarment decision. And at that point, the reason they did so was they found that the agency had ignored critical evidence. They hadn't reviewed it, and they had just kind of streamlined and made a determination without really going into the individualized evidence and claims. So that was, as it sounds, more of a procedural failure on the agency's part. But it was one of the few cases that we've seen really where the court took the agency to task and really reversed the decision. These agencies, because of how devastating a suspension or debarment is, there's a real need to try to obtain some sort of injunctive relief to get the court to weigh in and say, we're going to reverse the suspension and debarment at least until we're able to rule on the case. So a lot of the kind of contractors that take these matters to the district court will seek a TRO or preliminary injunction to try to reverse the that kind of death penalty, at least for the time being. And the standard on that is stringent. It's the same standard that would apply to any other kind of preliminary injunction request. Usually you have to exhaust all your administrative remedies before you can bring a court action. That's not to say you have to appeal everything within the agency. It just means that you can't kind of jump a step and, if you feel like a suspension is coming, jump over to the federal district court. You have to kind of wait and follow the set procedure.
Thanks, Alex. So we've given you some background on why they suspend and what the causes are and what they look for and how the process is supposed to unfold. And it's probably a lot of doom and gloom. Like Alex rightly points out, it's a very slanted process in favor of the government. So, the best advice we can give you is to do things to not end up in that situation. Alex will talk in a few minutes about how to navigate the process and tips for doing so to at least try to get the best possible result if you're in that situation. But it is a difficult situation to be in, and there really is no result that is a total win for the contractor once you're in that situation, and it's not an easy process to navigate. The deck is stacked against you. So there are things you can do. I mean, beyond the sort of generic don't commit fraud and do the kinds of things that get you in an IG's crosshairs. The real advice is develop and maintain strong internal controls. Make sure that you don't just have these documents, although a lot of small businesses don't even have the documents, and that's understandable. I mean, one of the last things you can worry about and have time for, I'm sure, is a robust set of internal policies and procedures, particularly when you're small and it may just be you or a few people at first, and then you've grown, and the next thing you know, you're humming along, but you didn't go back to sort of establish or fine-tune these things that guide your company. And they're very important because you can do them after the fact, and if you got into a suspension or debarment situation, you would very well be required to put them in place after the fact. But from the standpoint of a mitigating factor, they're going to be a lot less effective if you're implementing them for the first time in response to an investigation. So don't wait. Go ahead and do these things or revisit them now. And the one that I like to champion is the policy and procedures for size and status representations. This is in direct response to the presumed loss rule that I talked about. One of the mitigating factors mentioned right in the rule is whether or not the contractor has policies and procedures for size and status representations. And what I'm talking about is some internal guidelines for before we say we're small or check the box for woman-owned small business or STVOSB or whatever it is. These are the things we're going to do to make sure that our status is still good. And these are the steps we'll take to escalate a situation within the company and then sometimes outside of the company to people like Alex and me if we're not sure. And we do all those things and we get letters in the file and other things to document what we've done, then we've done everything we can to have a good faith basis and we're not willfully or intentionally misrepresenting our size or status. So you should have policies and procedures and drill on those things, and that's where we talk about employee training. You got to make sure your people understand. It's not enough to just create several documents if nobody knows what they are or how to follow them, or they're sort of created and forgotten. You should be having regular training and compliance reviews, and make it a part of, at a minimum, your annual review process. You're probably doing it with your accountants already. Bring in an internal compliance or particularly a size and status review component to it. Where are we as we go into this new year? Where did our revenues end up? And is it enough now that with the 3-year rolling average we may have an issue with our size status this year? Check the box at least. Do that regular review. It'll be very helpful to avoid a suspension debarment situation, and certainly it's the kind of thing that people like Alex and I could use to your advantage if you end up in this kind of situation down the line. Have a designated corporate compliance officer, clear chain of command. Who's responsible for this ultimately? And is that person given sufficient authority within your corporate structure to do his or her job? That's important. Fine-tuning your teaming and subcontracting procedures is also important. Are you doing a risk analysis at the outset of your new projects based on your capabilities for the project? What I mean by that is, are you walking into an affiliation issue because this is really outside your realm and you're going to be unusually reliant on your subcontractor? Or the alternative situation would be your partner is the one bringing the necessary size or status to the project. Are they who they say they are? Did you confirm? Trust but verify, right? To go back to what we talked about earlier, the prime contractor could be liable for a misrepresentation of the subcontractor. And the way that would come up is if the prime contractor did not have a good faith basis to rely on the representation of the subcontractor. So as a prime, how do you get a good faith basis? Well, there's no clear guidance on that, but the best advice we could give you is to require them to give you a written representation in your teaming agreement, your subcontract, whatever document it is that you're using with them, and then go confirm that yourself in SAM. Are they who they say they are, and put it in a file. And you may want to go even a step further in requiring them to indemnify you if there's any loss associated down the line with a misrepresentation of size or status. And protecting your company's and procurement sensitive information. And I'm going to click over to the next slide here to drill down on that more. You know, we hear it is, I think, relatively common that people get inside information, or you're hearing something through the grapevine, and whether that's from people within the procurement shop, whether that's about or from people within your competitors. I think a good rule of thumb is be wary of that type of information. If it seems too good to be true, it probably is. You should ask the question of whoever's bringing this to you. How do you know this? Where did you find this out? What's the source of this information? And then ask, should we have this information? You know, even certainly if it has a legend on it, you know, that would indicate it's confidential and proprietary or subject to certain access restrictions, that's a clue. But even if it's not labeled, should you have it? You know, ask the question. Don't just you know, be blinded by what that information might mean for you in terms of a competitive advantage for the procurement. And maintaining good lines of communication with your contracting agencies and the personnel within them is obviously important for a variety of reasons, but you know, it can keep you out of trouble and make sure you have allies. So that's important as well.
Thanks, John. I'm going to touch on kind of once you're at that process, what do you do? As I mentioned earlier, what you normally get is you first receive a notice. Kind of the first thought you would, when you get something along the lines that your kind of natural instinct is to, you know, protest, deny, try to immediately call up the SDO and say, well, what's going on here? This absolutely isn't true. And that can be a little dangerous. We would recommend kind of first focusing on preparation and information gathering and kind of getting on top of kind of what exactly occurred before you make representations to the agency. You want to kind of ask for the administrative record from the agency to kind of see what they're basing this decision on. You want to conduct your own internal investigation to see and kind of determine what happened. That way you're on top of kind of what happened, and that also puts you in a better position to remediate and take action. We would also recommend getting experienced counsel as well, just because of the you know, just the seriousness of this, and contacting the SDO I have here, that goes without saying as well, to kind of arrange for adequate time. The key is to get in front of the process and be proactive. Once you kind of know what's happened, you really need to get involved in and take actions to remediate what with the idea being, once you go into that meeting with the SDO, you want to be able to tout all of the things that you've already done to make sure that it never happens, because the SDO is going to be thinking of this as in terms of, is this contractor presently responsible? And you know, so if you get up there and go, well, I fired this guy who did this, I've, you know, increased our training, I've made sure that we have these internal controls strengthened, this event can't possibly occur again because we've taken these 5 very significant steps, that's going to be something that will work in your favor. So kind of steps you could take: you can implement stronger internal controls, investigate what happened. One of the mitigating factors Jonathan was mentioning was disclosing your investigation to the government, so that's another thing you can do. Disciplinary action is one of the more impressive things you can kind of tout, you know, when you're talking with the agency, and increased training goes without saying. Once you're meeting with the agency, we recommend meeting with the agency. It's one of the things the FAR outlines that you're entitled to normally. We would push for a meeting as quickly as you can get one, but not so quickly that you don't have your investigation complete and you don't have your kind of steps in place. They may not be willing to meet with you before you make a written response, but you should definitely see if they will. If you're able to meet with them before they even consider suspension, and sometimes they just impose suspension before they even talk to you, But if you are able to meet with them, we definitely recommend that because of just the draconian nature of a suspension. You really can't be prepared enough for this types of meetings. As John was mentioning earlier, it's one thing to have your attorney at the meeting, but really what the agency is going to be looking to is the owner, the principals, people involved, how seriously they're taking it, and whether they, quote, get it. And that's going to be something that you can hire the best attorneys in the world like Bill Gates, but when it comes time for the deposition that he took, he looked awful. It's just a lot of the people, you just need to make sure that you're conveying how seriously you're taking the situation and you're preparing not only as an attorneys, but also the principals of the company. You should use the mitigating factors that Jonathan was going into, and they're also listed in the FAR, as a roadmap of kind of what to emphasize and what to show the agency in terms of how to make that present responsibility determination.
Yeah, and I think, regardless of our perspective on the fact that suspension debarment really is a punishment, reminds them that it shouldn't be a punishment. And it's not supposed to be wielded as a punishment for past misconduct. It's supposed to be to protect the government against a contractor that is not presently responsible. So one of the main things I think you're doing in these meetings is trying to bring it back to, even if the agencies continually focus on what happened in the past, keep trying to bring it back to present responsibility and the things that you've done along those lines.
Absolutely. The last kind of slide here is administrative agreements. We're seeing an increased use of these, and the reasons are pretty simple. That it's one of those things where the standards are so low for the government to meet, the impact on the contractor so harsh that it really pays for the contractor to try to settle these disputes in any way that they can. And an administrative agreement is a way for the agency to settle with the contractor. It's kind of a win-win for all sides because the agency can tout that they're tough on crime, while the contractor can avoid the death penalty in some cases. So the way that the administrative agreements kind of shape up is they oftentimes agree to additional controls or reporting to the agency, independent monitors, increased training. These kinds of provisions that we were talking about earlier put together into a more concrete settlement agreement. It's something that the agency, it's also a way for the suspension and debarment officials to avoid having their decisions reviewed, because if you actually impose the suspension or debarment, that becomes public and then subject to an appeal right, where it's a way for the SDO to kind of tout that they're tough on crime without having to impose that penalty and kind of be subject to scrutiny as to why they brought the action in the first place. They'll generally grant the administrative agreement if you're close to presently responsible or if you're presently responsible. You've seen it a lot more recently, and really it's only with the very bad actors where there won't be any chance for an administrative agreement. So you will see that possibility of an administrative agreement being definitely there. And then, going into the meeting to try to get that administrative agreement, we recommend you think about it beforehand, kind of what steps, what terms you might agree to, what potential terms the agency might raise that you wouldn't be able to agree to, and any kind of countermeasures. As we mentioned, it doesn't hurt to prepare.
Thanks, Alex, and thanks everybody for participating. We have a few minutes left, and we have a few questions. Maybe, perhaps not surprisingly, not a lot of questions. This may not be the topic where everybody, a friend of mine would like to know type of question maybe, but if anybody wants to submit a question directly to us afterwards that didn't feel comfortable submitting during the presentation, please by all means go ahead. But somebody asked about whether or not there's a list of all of the suspension debarment officials. I'm not aware of a master list across all agencies, but at least I can think of certain agencies that we've dealt with. The contact information and the SDO is often identified on their website, so it might take a little bit of digging around, but I think at least for the major agencies, I think you can find that information online. If you have any difficulty, though, with a particular agency and you want to follow up with us directly, we'll see if we can get some contact information for you. And a couple people asked questions about a comment that I made related to size status, and I think it was the comment where I said, at a minimum, do an annual review, and as the calendar turns over to the new year, what impact does that have on your small business status for the coming year? Your size is determined based on your 3 most recently completed fiscal years, the average revenue in those 3 completed fiscal years. So I'm assuming for most folks that it's a calendar fiscal year. So when you get to January, like let's just use January 2015 as the example. When you get to January 2015, 2014 at that point will be a completed fiscal year and will be included in your 3-year average. So, and you may not know immediately as of January 1, 2015 what your 14 revenues looked like, but the point being, once you tick over to a new year, you've got another year that's been added, a new year that's been added into your 3-year average, and you've got to figure out what impact that has on your small business status. You would not have to revisit that throughout the rest of the year because it will not be until you have a new completed fiscal year. So if you're small as of using the 2012, 13, and 14 period, you would be small under that measure for all of 2015. It would be, you would check again once 15 is a completed year and is added into your average. And with that, I'm going to have to wrap up. There are a few other questions we will answer via email, and please do not hesitate to contact us if there's anything that you would like to ask us specific to this. And again, thank you very much for participating.
Thank you, everyone.